for joining us today. I'm partner Asad Ahmed, head of antitrust and competition at GLA. I'm delighted to welcome you to this webinar and to introduce GLA and Co., the leading regional law firm serving the Middle East and North Africa. We're a full-service regional firm with 8 offices across 7 key jurisdictions: Kuwait, Saudi, UAE, Qatar, Bahrain, Oman, and Egypt, bringing together more than 170 lawyers, including 18 partners. Our footprint enables seamless bilingual counsel, Arabic and English aligned to local business realities and regulatory nuances in each market. Complement our on-the-ground teams with premier members and associated firms to deliver consistent quality and unified execution across jurisdictions with a single point of contact for cross-border matters. Clients value our regional coverage and single team coordination across offices. We combine rigorous local law capability with global execution standards supported by secure technology-enabled collaboration across offices. Now, with respect to our antitrust and competition practice, specifically merger control, I'm extremely proud to announce that our team has successfully obtained over 100 clearances in the past 18 months across the GCC and Egypt. Currently, GLA has active merger control filings in 5 of the GCC states plus Egypt. We enjoy a close relationship with all of the regulators and are able to sit down and have honest discussion with them to create good precedent jurisdiction. The days of relying on only black letter of the law advice are long over. With the rise of the regulatory bodies in these jurisdictions in the last 5 to 6 years, the practice of regulators has become more important than the black letter of the law. Ignoring practices of regulators, ministries, or municipalities in the region today is per se negligence. Now, this webinar is intended to have a lightning round theme Q&A format where we provide you with important information regarding each jurisdiction's merger control regime, regulatory practices gained through our on-the-ground experience. Okay. With that being said, I'd like to introduce some of our antitrust and competition team members who will be speaking today. From our UAE offices, we're joined by Senior Associate Khalid Abu Arabi. From our Qatar offices, we're joined by our Associate Jihan Saleh. From our KSA offices, we're joined by our Associate Omar Halbouni. From our Egypt offices, we're joined by Associate Khalid Al-Khashab, and from our Kuwait offices, we're joined by Associate Khalid Al-Makhazim. The first question to each of the jurisdictions will provide a high-level overview of the merger control regime, but thereafter, each subsequent question will be unique to that jurisdiction as the regulators have practices. Now, please feel free to ask questions in the chat side, and we'll try our best to get them to them live or answer them privately after the webinar. Without further ado, we'll now begin with a question starting with the UAE and Khalid Abu Arabi. Khalid, if you can give us a quick summary of the merger control landscape in the UAE.
Good afternoon, everyone, and thank you for joining us. The UAE takes a very broad approach to merger control. Under Federal Decree Law number 36 of 2023, it's not limited to classic mergers. Any transaction that results in a change of control can potentially be caught. That includes acquisition, asset deals, share transfer, and even arrangement that gives indirect influence. What really matters is the effect, not the location. A transaction does not need to happen in the UAE to be relevant. Foreign-to-foreign deals or even IP arrangement can trigger a filing if they have an impact on the competition in the UAE. From a competition perspective, dominance is generally presumed once a 40% market share is crossed, and the Cabinet Resolution number 3 of 2025 give us a clear merger control threshold. A filing is required if the parties' combined UAE turnover exceed 300 million dirham, which equivalent to 81 million USD, or if their combined market share exceeds 40%. There are some carve-outs, mainly of certain sector regulated activities or designated government-owned entities, but they are quite limited. The key takeaway is The UAE has a mature, effect-based merger control regime with a real extraterritorial reach. That's why early competition analysis, even at the term sheet stage, is no longer optional.
Thank you so much for that, Khalid. Brilliant. We're going to move quickly on to Qatar. Han, can you give us a quick summary of the merger control landscape in Qatar?
Yeah, so Qatar's merger control regime stands out from most of its neighbors due to an absence of financial notification thresholds. The law that regulates Qatar is Law number 19 of 2006. So, as you can hear from the name, it's quite old, and there are plans for a new law to come out quite soon, which we will talk about later. Under the Qatar competition law, there are no prescribed turnover or market share thresholds, which trigger a mandatory filing. Instead, merger control is assessed on a qualitative effects-based test. It focuses on whether or not a transaction will result in control or domination of a relevant market. So this approach is very fact-specific, it's case-by-case analysis, and it places a heavy analytical burden on parties and their advisors compared to the threshold-driven regimes in the neighboring jurisdictions. Economic concentration is not defined in the law, and it's quite abstract, which again is different than its neighbors. Everyone does have to file in Qatar anytime there's a merger or acquisition, but the positive news is that you don't have to pay for it. There are no filing fees in the region. Regulators are eager to become more active and for parties to initiate more filings with them, and this is going to be seen in the new law that is coming out.
Wonderful. Yeah, I mean, in Qatar, the regulator is definitely eager to become quite a bit more active. So that's a good note. Moving on to our next jurisdiction, Khalid Khashab with Egypt. Can you give us a quick summary of the merger control landscape there?
Thank you, Assad. So to say that Egypt has a merger control regime that is equally sophisticated as to its neighbors in the region. However, it is young. It's only been operational for about a year and a few, starting June 2024. But nevertheless, the statistics tell you that there's confidence in this evolving region. We've got almost officially about 100 filings since the initiation of the program in 2024. It is still developing. There are certain uncertainties given the nature of the transaction itself. But the beautiful part is the ECA, the competition authority, has been around for a very long time. The law came out initially in 2005. There is a lot of expertise. So navigating these uncertainties has been developed by practice. There's a lot of guidance that comes out of the ECA, such as the Q&As that the ECA publishes, which shed the light on the practicalities, how common issues are navigated. The ECA has a lot of public relations aspect to that, which it tries to reach out to the stakeholders just to make sure that the process is as smooth as it gets.
Okay, thank you so much for that. Yeah, any guidance from the regulators is definitely a plus, but then also being able to have discussions with them how they're going to implement these new guidelines. The ECA is very open on that front, so we appreciate that. Moving on to the next jurisdiction, and that's Saudi with Omar. Can you give us just a quick summary of the merger control landscape in Saudi?
Yeah, for sure, Assad. So the Saudi merger control regime is comprised of the competition law of 2019, its regulations, its guidances, and also the General Authority for Competition, also known as the GAC or GAC. So the competition law uses the principle of economic concentration to identify merger control issues. So an economic concentration is defined as any action that results in a total or partial transfer of assets, rights, equity, stocks, shares, or liabilities of a firm to another by way of merger, acquisition, takeover, or the joining of two or more managements in a joint management, or any other form that leads to a control of an entity, influencing of its decision making, the organization of the administrative structure, or its voting system. In addition to that, the economic concentrations are realized and they are fileable upon three financial thresholds being met. So, for one, the combined worldwide annual sales of all entities exceeding 200 million Saudi riyal, which is around 53 million USD. The target exceeding 40 million Saudi riyals annually, which is around 10.7 million USD, and the KSA entity exceeding 40 million Saudi riyal, or 10.7 million USD as well. Failure to notify the GAC of a reportable economic concentration can result in fines up to 10% of the annual global sales of the violating entity, or up to 10 million Saudi riyal if sales cannot be estimated.
Okay, thank you for that, Ahmed. I mean, I think with KSA, the important thing to note is how broad the definition of economic concentration is there. And the fact that all three financial thresholds now need to be, it didn't start off that way. So they've made progress quickly in that jurisdiction. Again, thank you, Ahmad. We're going to move on to our final jurisdiction with Khalid Al-Makhazim in Kuwait. Khalid, if you can give us an idea of the merger control landscape in Kuwait today.
Yes. So a merger in Kuwait is governed by law number 72 of 20, under which economic concentration arises is a permanent change of control in relevant market. This includes mergers by absorption or combination, the acquisition of direct or indirect control over all or part of another business, whether through the acquisition of shares, assets, ownership rights, liabilities, or by any other means, as well as establishment of partnership joint venture that carry out an economic or commercial activity on an independent and lasting basis, regardless of their legal form. Additionally, the law provides for three objective quantitative financial thresholds, and where any of the parties to a transaction meets at least one of these thresholds, the transaction is subject to merger control filing here in Kuwait.
Okay, thank you so much. I really appreciate that, Khalid. And again, these jurisdictions are quite unique. Kuwait, if only one of the financial thresholds is met by the parties or any one of the parties, then automatically a nexus is presumed in that jurisdiction and it becomes fileable. So that's something we need to note. Moving on to our next question, and we can go to the next slide here. We're going to start off with UAE again. And Khalid Abu Arabi, can you, when and how do we submit a merger control filing, and what happens during the review process there?
Here, timing really drives everything. A filing must be submitted at least 90 days before completion, and there is a strict standstill obligation. That means no closing, no integration steps, and no transfer of control until clearance is granted. Once the filing is accepted as complete, the ministry has 90 days to issue its decision. There is also one-time extension of up to 45 days. Importantly, if no decision is issued within the statutory period, the application is deemed rejected. Parties can offer remedies either with the filing or within 30 days after the filing is accepted. The ministry may also publish basic details of the transaction to invite third-party comments. The review clock can pause if the ministry asks for additional information, seeks technical inputs, or if appeals are submitted. And outcomes range from unconditional approval to conditional approval, prohibition, or confirmation that no filing was required. Practically speaking, Arabic is the controlling language. Certified translation, notarized and legalized power of attorney are often required. That said, and based on our recent experience and filing, the ministry has shown flexibility and has accepted soft copies unless original are specifically requested.
Okay, thank you so much for that, Khalid. And I think it's imperative to note that these little situations where that you can get them to accept soft copies can make a huge difference with respect to the timing of things. Thank you for that, Khalid. We're going to move on to our next jurisdiction, Qatar. And Jihan, how active has merger control enforcement been in Qatar recently? Can you give us an idea?
Yeah, so in the past, merger control enforcement has been relatively light. However, we can see now that it is clearly developing. In 2025, there were 2 merger filings. Both transactions were approved. And there was also a third acquisition that was cleared by way of formal exemption rather than standard approval. And this approval was conditional on the entity meeting certain conditions following the acquisition. So this aligns with the structure of the competition law, which provides for mandatory notification where a transaction creates or is likely to create a control situation. And it is allowing the authority to clear transactions that contribute to economic progress. We have spoken to the regulator and they have stated that they intend to be even more active than they were in the last year. And this is definitely going to be facilitated through the new law coming out.
Okay, yeah, thank you for that, Jihan. And I mean, obviously, Qatar, it is a small jurisdiction, but it is becoming more active, and we have to keep an eye out for that. Moving on to Egypt and our next jurisdiction with Khaled Al Khashab. The question there is, we understand that Egypt has more than one competent authority to review merger control filings. How does the regime provide for such synergy?
Thank you, Assad. So, under the Egyptian competition law and the executive regulations, the ECA, the competition authority, is the competent authority with reviewing merger control filings. However, the the law and the executive regulations provide the technical aspect where if a target entity is governed or is undertaking an activity that is supervised by the Financial Regulatory Authority in Egypt, then the FRA acts more of a channel at this point for reviewing such a filing. Now, the ECA is not taken away from the filing. In that case, it provides its opinion to the FRA. It also undertakes to provide the relevant RFIs. So it's more of a synergy of the FRA looking into sector-specific aspects and the ECA looking at the overall merger control / competition aspects. So the synergy is more of a channel / coordination that would allow a target entity or a transaction that involves a target entity that is FRA supervised to be properly reviewed.
Perfect. Thank you so much for that answer, Khaled. Moving on to our next jurisdiction, KSA and Omar. This is a very common question we receive, but how quickly can a client prepare a merger control filing for clearance there?
Yeah, for sure. And Asad, this is going to be contingent on a couple of things. Okay, so for one, it will depend on how fast the client can get their documents in order for submission to the GAC. So, for example, the acquirer, the target, they're going to need to provide a power of attorney. And the great thing with KSA is, unlike some of the other GCC countries, they are a signatory to the Hague Convention. And therefore, their power of attorneys will only need to be apostilled as opposed to needing to be legalized up to the consulate in their jurisdiction, which can save a good amount of time, right? In addition to that, KSA also accepts documents in English and in Arabic, which has saved, plenty of time on when it comes to the translation timelines and even the costs. Furthermore, if documents are not in English or in Arabic, a summary of the document can be provided in English, and it doesn't even need to be certified. So these little nuances, right? They tend to save a good amount of time when it comes to getting prepared for any filings in the KSA.
Yeah, I mean, that's very unique to Saudi, and I appreciate you making those points. I do have one follow-up, though, for you. If you can just, give us an idea, how long does it take to actually receive a clearance from the GAC?
Yeah, good question. And Asad, this is going to depend on the type of transaction. We've seen straightforward transactions get clearance within 10 to 15 business days from submission of payment to getting the clearance. And this is obviously dependent on if there are no requests from the GAC for further information on the transaction. But we've also seen transactions get approved within 5 days of submission of payment, right? So it's really going to be contingent on the transaction.
Yeah, that's incredible, though. That statistic of 5 days from payment, that's definitely leading the region, and hopefully we can continue to move towards that with all leaders. Thank you for that, Ahmad. We're going to move on to our next jurisdiction, Kuwait, with Khalid Makhazim. And the question for you is, what is the typical timeline from submission to clearance of an economic concentration application with the CPA in Kuwait?
Yeah. So the Kuwaiti competition law requires an application to be submitted to the CPA within at least 60 days from the date of the transaction agreement. In practice, clearance is typically obtained within 45 to 60 days from filing. This time is not applied, and the CPA generally shows flexibility. Also, filing fees apply and are calculated at 0.1%, the lower of either the paid-up capital of the parties or their combined assets in Kuwait, capped at 100,000 Kuwaiti dinars, and such fees must be paid prior to submission. One last important aspect is that transaction may not be implemented before the CPA issues its approval.
Yeah, thank you for that, Khalid. I think one of the things to note here, and that's why there's a big difference between the back letter of the law and the practice. For example, Khalid mentioned that you need to submit the merger control applications 60 days clearance or prior to closing. I'm sorry. That is on the books. It is a law. However, in practice, the CPA does not strictly apply that, right? So there is the difference between the two. Thank you for that, Khalid. I do see one of the questions I'll quickly answer in the chat. Ziad, in KSA regarding GAC line for approval, how long can it take for deal from the day of payment? So basically, once you reach to the point where you're paying, that things are streamlined. From payment, it's typically 3 to 5 days. But prior to that, once you do the submission, the GAC, they may, if it's a complex transaction, they may with 1 or 2 rounds of request, which would take anywhere between 5 to 10 business days, usually. And then thereafter, once they have no further things, they'll move on to and provide you with the calculation payment. You'll make the payment, and then it's procedural from there on out in terms of clearance. Okay, we're going to quickly move on to the third round of questions. And we're going to start again with UAE. Khalid Abu-Arabi, the question for you is, what if parties fail to submit for a merger control file? Or, they close before the clearance is provided. What exposure are they looking at there?
Actually, Asad, this is where the risk become very real. Failing to notify a notifiable transaction can lead to fines ranging from 2% to 10% of the relevant UAE turnover of the last fiscal year. If the turnover cannot be calculated, there is a fallback fine between 500 to 5 million dirham, roughly between 136,000 to 1.3 million USD. Breaching the standstill obligation is a separate violation, even if it only partial and carries additional fees. Courts also have the power to order temporary business closure and publication of judgment without affecting the right of third party to claim civil damages. Competition cases are handled under expedited procedure, and courts can grant interim relief. So if a failing is missed or a transaction closes too early engagement with the ministry becomes critical. In those situations, remedial measures and hold separate arrangement should be considered immediately.
Okay, thank you for that. I mean, it's important to note that these jurisdictions are becoming more serious with gun jumping violations. I'll stop here and take one more question for UAE since we're on UAE. And I don't want to butcher the name, but Kinshuk, I believe. In UAE, when does the 90-day period commence, and does the MOE provide a reference number for applications for identification purposes? Number one, the 90-day period commences when the submission is provided and they tell you it's complete. You can typically, before, they used to require soft copies and hard copies, and the statutory period did not start until they received all copies. They've gone away with this, and now they've accepted the soft copies as being the beginning of the statutory period. And thereafter, they will give you a reference number for the submission as well. We're going to move on now to Qatar and Jihan. Jihan, have any transactions been rejected or sanctioned so far by the regulator in Qatar?
So there has been one very notable rejection, which was the proposed acquisition of Careem in Qatar by Uber. And the Qatar Competition Authority blocked this deal on competition grounds because the transaction would lead to a dominant position and lessen competition in the local ride-hailing market. This was communicated privately to the parties in August of 2019, and Qatar was one of the few jurisdictions that actually did not clear the transaction, even though it was approved in UAE, where Careem was actually founded. This decision was not publicly announced in any official gazette or via press release. It was communicated privately to the parties, but it was disclosed by Uber in an SEC filing. So there also have not been sanctions yet at the moment. However, sanctions are a very real part of the law. And with the increased movement by the Qatar Competition Authority, that we will see more sanctions being enforced. And at this point, we shouldn't see the lack of rejections or lack of sanctions to be considered as a regulatory passiveness. The competition law, of course, empowers the authority to investigate, issue stop orders, impose financial penalties, which include significant fines and even confiscation of profits. So the regulators are scanning for announcements. So that's important to note.
Perfect. And I think it's important, again, to note that even if jurisdictions like Qatar has not been as active, don't be surprised if in the next 6 to 12 months, see a lot more activity coming from them. They do have the authority to do things, and they do want to get more involved to ensure that their markets stay and healthy. Okay, thank you for that, Jihan. We're going to move on to the next jurisdiction, Egypt and Khashab. Khalid, I have a very specific question for you. Can POAs be issued from outside Egypt in foreign languages only?
Yes, Asad. Just to give a bit of background on this one. So the statutory requirements are generally that documents presented to the ECA should be in Arabic. That includes the POA, which is the common way of having a valid POA in Egypt. Nevertheless, from recent exercises we've been doing, including a very specific one that has to do with Canada, the ECA is aware that, similar to other jurisdictions, there has been shift in the legalization requirements. Canada, for instance, is moving towards only apostilling and abolishing standard legalizations. It came to our attention that the Egyptian consulate in Canada is aware of that, so it allows for only apostille documents. It also allows for English-only POAs to be issued, or foreign language only. So the overall, we've seen in these exercises that yes, POAs can be issued in a foreign language, though the most tested till date is English. It is recommended that if English is an option, it is granted sort of leniency with the ECA, and it's more on a case-by-case basis for the translations, but the overall is yes, English POAs can be submitted before the ECA.
Okay, very clear. Thank you for that, Khalid. We're going to move on to KSA and Omar. The next question for you is, are there any merger control exemptions under the competition regime today?
Yeah, so there are a couple, and simply put, if the transaction does not lead to a change of control over the target entity, then no GAC filing is going to be required. All right, so that's one of the exemptions, right? The second one revolves public institutions and state-owned companies if they are solely authorized by the government to supply goods or services in a certain field. And such exception is going to be effective only by way of a royal order or royal decree, Council of the Ministers resolution, high order exclusively authorizing such establishment or company thereto. And just to be clear, this is for direct public institutions, but it does not include their subsidiaries. So, I mean, the easiest example I can think of would be PIF entities. PIF entities, they're exempt under this rule, but PIF subsidiaries, they're not going to be exempt under this rule because they're not a direct public institution.
Yeah, I think that's an important distinction to make. And since we are on KSA, I do want to answer one question from Asfand with respect to KSA. And you're asking, is there a local nexus or effect requirement in Saudi for a transaction to be notifiable? And if so, what is the test? There isn't a local nexus test, but it's foreseeable, direct and foreseeable type of test. However, I would almost say it is irrelevant because you have objective threshold that all need to be met. And if they are met, then it's almost presumed that the local nexus exists. Okay, so that's kind of the assessment or analysis that I would do as fond, but there is a local nexus test. It's in the books. It is part of the law. Okay, we're going to move on to the next jurisdiction, Kuwait and Khalid al-Makhazim. Does the CPA accept the use of apostille, and do they accept documents in foreign languages? We always get to this question, Khalid, I know you know quite frequently. So can you give us an answer for this?
Unfortunately, Kuwait does not accept apostilles. All corporate documents issued outside of Kuwait must be fully legalized by the Ministry of Foreign Affairs in the country of then by the Embassy of the State of Kuwait in that country, and finally by the Ministry of Foreign Affairs here in Kuwait. The legalization timeline varies depending on the country of issuance and the relevant authorities' procedures. In practice, this process typically takes approximately between 2 to 4 weeks, and in some cases longer than that. In addition to that, the CPA does not accept documents submitted in English or any other foreign languages. All documents filed with the CPA must be translated into Arabic by a certified translator licensed here in Kuwait. Any document that is not accompanied by official Arabic translation will not be accepted by the authority.
Khalid, I just want to make sure the connection's okay. Khalid al-Makhazim, are you still there? Okay, we may have, okay, I think everybody's we've just had a little technical issue. Okay, we're going to move on to the next round of questions now, round 4. And the question starts with you, Khalid Abu Arabi there. What are the key steps for analyzing a transaction under the current UAE competition law before making a merger control filing, if one's required?
Yes, so everything starts with market definition. You first identify the relevant product market. In simple terms, what customers see as substitute, and then the relevant geographic market, meaning where competition actually takes place. Once that's clear, you assess the market shares and competitive effects. A dominant position is generally presumed once an undertaking exceeds 40% of transaction in that market, or where it can otherwise influence competition. This step is crucial because the notification thresholds are tested within the defined market. Only after that exercise can you determine whether the turnover or market share threshold are met and whether filing is required. That same analysis feeds directly into the filing. The ministry does not just expect a transaction document and the group chart. The ministry expects a credible competition assessment, including market shares, key competitors, barriers to entry, and any efficiencies. Where overlaps raise concern, addressing them early often makes the difference between unconditional clearance and approval subject to conditions.
Okay, very clear. Thank you for that. I think an important note there is that it all starts with the relevant market. It all starts with defining the relevant market, and then the assessment or analysis for UAE kind of goes from there. Moving on to Qatar and Jihan, the question for you there is, what should businesses expect under the new anticipated merger control framework?
Yes, so as we noted before, the current law was from 2006, and we are anticipating a new law to come out soon. One of the most important changes that hopefully will be coming with the new law is that not every single transaction will require a filing the way it automatically does right now. So this new framework is going to include turnover-based thresholds, and this won't necessarily be included in the law, but will hopefully be included in the executive regulations. And essentially the goal of this is to ensure that not every company is required to file a notification under the law. Second is going to be also to this point, which is greater clarity on who bears the filing obligation. So going back to what I just said, they indicated that clarity and transparency is going to be more so, and it's going to allow for greater adherence to the law. And there's going to be a stronger focus on competitive effects rather than formal deal structures. And finally, penalties will be enforced. As we had stated earlier, they have been not as enforced. However, this is something that's going to change. In the current law, fines range from 100,000 Qatari riyals to 5 million, alongside potential confiscation of profits. So these penalties may be rewritten in the new law, but it's definitely going to be enforced.
Wonderful. Thank you so much, Jehan, for that. Again, this information you're not going to find this information out there. So it's very interesting, and we're waiting to see what happens in Qatar in the next 6 to 12 months. I'm going to take one question. Reem is asking, where can I find data on the work of the competition department, especially those related to merger control? I think this is with respect to Qatar. She's conducting some kind of study there. So they do have some material on their website, and they have a pamphlet that they recently issued. But other than that, you're not getting any public information. Our information is through our relationship with them. We do speak with them quite often and have a good relationship. They're happy to email us. We can set up a call with you and discuss those things. Alex has a very good question, and this is very relevant to UAE, and I really want to take this before moving on. Alex asks, with respect to the application of the new revenue threshold in the UAE, does the authority look at the party's total revenue in the UAE or revenue in the relevant market in the UAE? It's a very, very important distinction. I'm so glad that you pointed this out. It is actually the relevant market. The financial threshold applies to the relevant market, not to your entire revenue in the UAE, hence the reason for defining relevant market. Okay. We're going to quickly move on, guys. The next jurisdiction is Egypt, and Khaled Khashab. The question for you is, when do transactions require multiple merger control filings in Egypt? Very interesting question.
Thank you, Asad. So, as explained earlier, there has been synergies between the authorities and within the ECA in terms of sectoral aspects. One specific case that is explicitly recognized by the ECA is the case of share swaps. Now, share swaps are recognized as two separate filings, even if it's a specific one transaction. The rationale behind this is that in a share swap, you have two separate targets and two separate acquiring entities. So this kind of an acquisition or this kind of a deal structure is recognized as a multi-filing situation. Another situation that has to do with the aforementioned FRA filings. Now, the straightforward case is that when you file before the FRA, you're undertaking an FRA regulated activity. Some other companies have very broad set of activities that they directly undertake, not through their portfolios, which would fall outside of that supervision. In that case, you must provide a filing before the ECA for these separate activities on their own. Now, I understand that this might sound a little bit concerning in terms of multi-filings and timelines, but we do have to note that the statistics, and from our relationship with the ECA, we understand that the numbers speak for themselves. The average statistical timeline for the turnaround has been 17 days for standard filing requirements in Egypt, as well as 12 days for the simplified procedures. So the timelines, even in cases of multi-filings, shouldn't be a concern. One last point that I would note on multi-filings is that though it's not an official filing, but we've seen in a couple of FRA-related transactions that the FRA might require a separate competition assessment to come out of the ECA. We've seen this with the cases of change of control the indirect change of control over FRA-regulated entities in Egypt, which has subsidiaries in Egypt. And we've seen this also in some restructuring works where the FRA would raise a concern that this restructuring could have some competitive effects. So in that case, it becomes almost a filing before the ECA. An official submission would be made, communications will be made, and official letters would be eventually sent out to the parties.
Thank you so much for that, Khalid. I mean, I think the biggest point I take for Egypt is early engagement, right? You need to engage early with the regulator, with the local council to have a clear way forward, just so everybody's on the same page with the transaction language is proper, and everybody understands the road forward, okay? We're going to move on to the next jurisdiction with Omar for KSA. With boots on the ground, what are you seeing in terms of any trends or recent statistics that can shed light on the KSA merger regime there?
Yeah, so in 2025, the GAC received in total 427 economic concentration applications. In terms of the percentage of the transactions, we have acquisitions that were leading the way at around 86% of all economic concentrations. In terms of sector, we have the manufacturing sector. They accounted for the largest share of the distribution with 73 applications. In terms of the international versus local market, one of the most mind-blowing stats was almost 70% of transactions only involved foreign entities. 69% to be exact. 17% of the transactions involved local entities, and 14% of the transactions included one local entity. At the country level, we have the US leading the way at 22% of all applications, followed by the UK at 7% and the UAE at 6%. In terms of the area, we have Riyadh dominating the percentage. Around 55% of applications are centered in the Riyadh region, followed by Mecca at 25% and the eastern provinces at 13% respectively. And now probably the most mind-blowing stat was the total deal value of these applications. Ready for this, Asad? It was almost 2 trillion Saudi riyals in terms of deal value, which is around $525 billion.
That's incredible. That's incredible. And you know, Saudi
USD, sorry, USD. I want to make 525,000 or million, 525 billion USD. My apologies.
That's okay. Thank you so much for that. Very interesting what's going on in Saudi and the quick developments there. We continue to see a rise in economic concentration applications and just merger control applications overall, including waivers there. We're going to move on to the next question. And for Kuwait and Khalid al-Makhazim there, can you give us an idea of the penalties for implementation of a transaction before obtaining clearance? So the gun jumping penalties in Kuwait.
Yeah. By the way, Asad, the CPA monitors media networks for any transaction-related announcement,
Right.
and also coordinates with the foreign competition authorities on such matters. They issue indicatory letters to involved parties, both within and outside Kuwait, which must be responded to. As for penalties, there are penalties in the law. It's that does not exceed 10% of total revenues of the concentration participant during the preceding financial year, in case of failure to submit the concentration application set out in Article 12 of the law.
Thank you so much for that, Khalid. I think it's important to note there that the CPA does not publish all of their penalties or sanctions, okay? And in the event parties enter into any settlement types of agreements with CPA, then they definitely will not be publishing that. And we're quite aware of a few instances where that has occurred, and we've represented people against the CPA or companies against the CPA when they have been sanctioned. So thank you so much for that, Khalid. I think that's imperative to know moving forward. All right, final round of questions for the jurisdictions. We're going to again start with UAE, Khalid Abu Arabi. The question for you is, how should merger control risk be addressed in transaction documents under the UAE competition law regime? Question.
Yeah, so a key message I keep coming back is that UAE merger control risk must be identified early and clearly embedded in the transaction documents. There is a still misconception that if a deal is signed or closed outside the UAE, it falls outside the regime. That's simply not correct. What matters is whether the transaction affects competition in the UAE, even if the target has no physical presence here. Vitor, another common assumption is that minority acquisitions are automatically safe. In practice, that is risky. Control isn't just about shareholding. Veto right, board influence, strategic decisions, making power can be enough to trigger a filing obligation, and those rights often sit quietly in shareholders' agreement. We also see parties assume that no overlap means no filing risk. But the ministry looks beyond overlaps. It looks at the market structure, potential competition, and whether the transaction could strengthen a dominant position. From a drafting perspective, that's mean conditions precedent, long stop dates, cooperation obligation, and risk allocation clauses all need to be reflected in the UAE clearance risk. The review period is real, the standstill obligation is strict, and the delay do happen. Most of the issues we see don't come from aggressive transaction. They come from incorrect assumptions made too late. And once the documents are signed, fixing those assumptions become much and much harder.
Okay, no, thank you so much for that, Khalid. And I think, this is a great point to make here. When you have these new laws, and they are new, and some of them we're still even waiting on the second part, which is the executive regulations in some of these jurisdictions. It is imperative that you engage local counsel early. If you need to, you get multiple opinions, because how the new laws are being interpreted, some local counsel might differ. You understand, and some local counsel might have more of an avenue to discuss with the regulators than others. So it's imperative to engage local counsel early, and maybe multiple assessments done just to confirm in order to move forward. Okay, thank you so much for that, Khalid. We're going to move on to Qatar with Jihan. Jihan, what are the key risks companies should be aware of right now when it comes to the competition law in Qatar?
Okay, so I would say that the first risk would be gun jumping, which those familiar with merger control know that it's implementing a transaction before obtaining clearance where it is required. That is something that will definitely get you penalties or sanctions under the law. And the second is assuming that exemptions apply automatically without confirming with your local counsel. A lot of times, this can be miscalculated or misunderstood, and speaking to local counsel can help ensure that you understand correctly whether or not exemptions would apply to the transaction. And the third is failing to reassess notification obligations where multiple transactions occur within a short period of time, because this can also collectively trigger a review under the law. So again, while enforcement has been quite limited in the past, the direction is very clear, and there's going to be an increase in enforcement of merger control in Qatar. So that should be something on your minds.
Wonderful. Thank you so much for that. And very important information. We're going to move on to the next jurisdiction now, Egypt, with Khalid Al-Khashab. The question to you, there is possible that they may review a transaction that did not meet the financial threshold after it closes. So, this is a very interesting question, because we're talking about a transaction that initially doesn't even the financial thresholds, and it's closed. So where do we stand on a situation like that, Khalid?
Well, the answer would be a little bit shocking, but yes, the ECA can do that. It can review a transaction that is closed and was initially not part of a transaction, or it's not a transaction that meets the financial thresholds. Now, this all happens initially with the approval of the Egyptian cabinet. And as I told you, the ECA, it has the right to look at such transactions. The time frame for that is within a year of the implementation of that transaction. the ECA can go back and ask for a review of that transaction. Now, this happens when there are circumstantial evidence that that would prove that there are certain aspects that are not properly assessed, or that the parties maybe haven't disclosed or have addressed. These would include if there's evidence of any restrictions on the technological development or innovation in the market, if there's been any controlling of the market by price increases or decreases, there has been some reduction in quality, or there's been creation of any barriers to entry or expansion in the market. In that case, definitely the ECA is going to knock on the parties' doors.
Okay, I mean, I think that's shocking, and honestly, to see the level of authority that the ECA has in Egypt. So just because closed your transaction and you didn't even meet the financial thresholds, the ECA still has the authority, assuming certain criteria, that they can go and investigate. So thank you so much for that, Khalid. Very important information. We're going to move on to KSA and Omar. The question for you is, can you provide us with the different types of merger control submissions available in KSA under the current competition law regime?
For sure. So look, you have your full economic concentration filing, right? But then you also have your filing for request for no notifications require certificate. So with the no notification require certificate, you're going to use this route where the thresholds or the nexus, they're not clearly met, or there might be a questionable acquisition of the actual control. And the timing to hear back from this route will be around 15 days. There's no filing fee required for this route. And the key risk with this route is, the regulator could later come back and say, well, you know what, we disagree. This actually requires a full filing. As you've met the thresholds, there's been a change of control. Now, with a full economic concentration filing, you're going to be using this route when thresholds are met, there's a clear change of control, and the timing included with this, like I stated earlier, you're going to see around 10 to 15 business days from submission to get clearance if there are no further requests for further information from the GAC. And we've also seen times where you get approved within 5 days of submission. So again, dependent on the transaction. The cost for this route is going to be dependent on the annual worldwide revenues of the parties. It's capped at 67,000 USD or 250,000 Saudi riyals. And the basis is off of 0.02% actually. The key risks with this, I would say, it's possible that there's going to be some delays. If the regulators want to get some more documentation or do a further examination, it might cause a bit of a delay. But those are the two essential routes that you're going to be with in KSA.
Perfect. Thank you so much for that, Ahmad. Again, I think it's imperative to know these different aspects, the avenues that you can take with respect to filings. With respect to the notification request certificate, that is another name, obviously, is waiver, as you've mentioned, and typically we've seen that there's been some kind of maybe misconnect where people think also another filing called waiver and RNNRC, and there is not. And I'm very proud to say that our utilization of the waiver application, we've been 100% accurate, and the GAC has agreed with us 100% on all of our waiver filings. So thank you so much for that, Omar. Moving on to our final question with Kuwait and Khalid Al-Makhazim. The final question for you, Khalid, is: are there any new or potential changes to the competition law or CPA process?
Yes, the CPA has recently amended both the pre-notification application and the economic concentration application forms. Under the updated forms, applicants are now required to provide more detailed and comprehensive information, including details on ownership and corporate structure, as well as confirmation of whether any other authority in Kuwait or competition authorities outside of Kuwait have been notified. As a result, additional time and documentation may be required to ensure full compliance with the revised filing requirements. In addition, proposed amendments to the CPA law are currently under discussion between various authorities in Kuwait. The anticipated changes may affect the penalties provided under the law and may also impact filing procedures and regulatory requirements. At this stage, the amendments have not yet been finalized, and their scope and implementation timeline subject to further review and approvals.
Okay, thank you so much for that, Khaled. Again, I think it's imperative to have these discussions with regulators often, have a good relationship with them, and we really do. This information that Khaled just provided with the PA is not out. If you don't have a relationship with them, or if you're in the middle of a merger control filing and you're utilizing the old form, it's not going to be accepted by the CPA. So it could affect the timing of the transaction. And if you don't enjoy that relationship with them, you may not know, because even some of the CPA members don't know that this is happening or this change has occurred. And it's also important to note that the competition law itself is looking to be amended a long time for the Kuwait merger control regime. So we're hoping for some good changes there. And thank you all again. Thank you for the panel. This is a very insightful panel and great practical information on the ground from each offices in these jurisdictions. I hope you guys enjoyed this. We will be getting to your questions are in the chat. We'll respond to you privately. So again, I hope you guys enjoyed this, and I'm sorry if we didn't respond to each of your questions, but we will privately respond. I promise you that. Thank you, and have a good rest of your day all. Take care.